Finance Committee will come to order. Members, Thursday, May 19th, and I'm sure you've noticed all these beautiful flowers at the table here. They are from Senator Benson, but all the boys here are taking credit for them, but it's Senator Benson. And I want to thank her so much because this is probably the last Senate Finance hearing for the year and the last of my career. So it's an honor to have this moment, and Senator Benson knows how much I love flowers, so very sweet of you. Thank you. Members, we have a full calendar today. We're going to start off with the House File 4670, which is the yearly claims bill, and we have Senator Bruce Anderson, who is on Zoom with us.
Good morning, Madam Chair.
Good morning, Senator.
Well, the annual claims bill is just what it is, annual, and kind of different than last year in the fact that we, again, had a difference of opinion between the Senate and the House in regards to how the claims bill was to finish out as far as being passed by the House. House File 4670 was passed in the House, but it was passed with an amendment to delete most of the claims and only go with exoneration claims. And that amount of money that we claimed was $813,000 for exoneration, and the rest of the claims bill, which was originally about $954,000, has been diminished quite some. But I have Mr. Keenley with us this morning to give us the further details on how the claims bill turned out.
Thank you, Senator Anderson. Good morning, Mr. Keenley. Welcome to the Senate Finance Committee.
Good morning, Madam Chair. Jason Keenley, Assistant Deputy Revisor and Chair, Counsel.
Mr. Keenley, you have to get real close to the microphone.
Sorry, Madam Chair. Jason Keenley, Assistant Deputy Revisor and Counsel to the Subcommittee on Claims. The bill before you includes 3 exoneration awards. They are to Brian Allen Benboom, Benjamin Joseph Hill, and Joseph Z. Livingston. I don't know how much detail you would like me to go into as far as the exoneration claims process or the individual claims themselves, but I certainly have that information if the committee would like to hear that.
Senator Kiffmeyer.
Thank you, Madam Chair. Thank you, Mr. Keenley. I appreciate your being here today. Because I think this is the first time we've done an exoneration, or has it been done before in the claims process?
Mr. Keenley.
Madam Chair, Senator Kiffmeyer, we've done these a number of times. There was one in last year's bill. There were, I think, several in the 2019 bill. The first time it was done was before my time as counsel, which was 2017. So I believe there were ones in 2016, either 2017 or 2018, 2019, and then 2021. But again, I'm certainly happy to go through the
Yes,
process.
Senator Kiffmeyer.
Yeah, Mr. Keenley, if you would just briefly describe the process. What does it take to get to the point and how the money amounts are chosen?
Mr. Keenley.
Madam Chair, Senator Kiffmeyer, the process is largely done through the courts. Once there is a determination that a person has met the statutory requirements in order to be eligible, they file with the district court. The district court takes a look at that and determines if they're eligible to go through the process. If the district court determines that they're eligible to go through the process, then that goes to the Supreme Court. The Supreme Court appoints a panel that determines that's goal is to work to that amount. Oftentimes those are settled between the state and the claimant. Sometimes they go to more of a hearing, and then at that point the panel makes a determination. But in the majority of cases, there is sort of a back and forth between the state and the claimant. There are some parameters set out in statute as far as minimum award amounts and the types of amounts and awards that can be calculated into the determinations. And then those recommendations after that come to the subcommittee on claims. I take another look at those and make a recommendation to the subcommittee. as to, basically that everything has been followed, that the award makes sense according to the statutes, and all the process has been followed. The subcommittee then makes a recommendation, which we often put in here at the Finance Committee and in the House in the Ways and Means Committee.
Senator Kiffmeyer?
Yeah, thank you, Madam Chair. It's quite a process, and I think that's what I wanted to illustrate here. This is not an easy thing, first of all, just to even qualify and then get through all of that. It's a very challenging process, and I'm just really glad that anybody who was wrongly convicted and has had their rights restricted in such a way as this, to be compensated on that basis of that exoneration gives them a chance, go to school, start a business, do something, and that the state owes them that. We understand that sometimes these things happen, but we certainly want to make sure that we soften those consequences wherever we can. Thank you, Mr. Kingley.
Thank you, Senator Kiffmeyer. For the record, members, we do have a quorum. Further questions, Senator Marty?
Madam Chair, I'm not an expert in any of this about the claims stuff, but I was reached out to by Senator Latz's office about another individual who has a Supreme Court rule. I don't know if it's called an exoneration. The individual served apparently 8+ years in prison based on a incorrect, I'm not sure of all the details of it, but basically he was convicted of what was the equivalent of fifth-degree criminal sex conduct in Wisconsin and would not have triggered predatory offender registration in Minnesota, but for some reason he was charged with failure to register, which he apparently didn't have to do, and he served over 3 different times, served 8 years, 8.5 years in prison, and Supreme Court order from, I guess it didn't come in until March 17th, basically through the same process, apparently because the claims subcommittee wasn't ready for it, or they didn't have a chance to look at it, they figured it could wait another year, and this individual who's been apparently fairly indigent his whole life and has a young child, the idea why making him wait when the courts have basically ordered this amount. So anyhow, I'd like to move the 822 amendment, and maybe Mr. Cooney from the Revisor's Office can comment on it, because I know he's the one who goes through all these, but and maybe there's a reason we should not be doing it this year, but I just feel that somebody who's already lost 8.5 years to a mistake, I mean, this is apparently the workers' I don't know how the court has it, but I guess our legislation requires Chapter 611-365 that the claimant is entitled to monetary damages of not less than $50,000 for each year of incarceration, et cetera. And maybe because I know very little about this, I would, and I believe there may be an attorney here for the individual, but I know Mr. Kuhnel is the one who deals with this. So,
Thank you, Senator Marty. Mr. Keenly.
Thank you, Madam Chair and Senator Marty. Yes, it often happens, and it has happened again several times in the course of the subcommittee's history of me being counsel to the subcommittee, that we have received exoneration claims, in the months or weeks leading up to the subcommittee's hearing. As Senator Kiffmeyer sort of mentioned, this is a pretty strenuous process, and each of these claims, have individual circumstances that are what bring them up. In 2021 and 2019, and again either 2017 or 2018, the subcommittee received exoneration claims sort of in the same sort of time frame of a couple of weeks to a month and a half before the hearing. In all of those cases, I had taken the claims to the chairs to say, we can hear this. The subcommittee does have a rule in place that says that claims that are received before November 1st will be heard by the subcommittee, and then the chairs have the ability to waive that. In this case, the agenda had already been taken to the chairs, and with it being later than, this claim coming in later than the claims that have been held over before it, the sort of determination was made to not try to, do the research that I need to do to be able to make a recommendation on this. And so the claim was not heard in the subcommittee. Does that cover your sort of procedurally how this has happened in the past, and the recommendations that I make to the subcommittee?
Thank you, Mr. Kinley. So basically, the content or the process, the only problem with the process, it was filed late.
Madam Chair, yes, I haven't had a chance to do the level of
The due
research that I would
diligence.
typically do in order to make a recommendation. That's not necessarily part of the statute as far as what needs to be done. That's certainly part of the history of the subcommittee and how the subcommittee has worked in the past.
Senator Marty.
Madam Chair, I wonder if Senator Anderson could just hear real briefly from him on this, because again, he may not have even been aware of it. So I don't know. I mean, I don't know when the Supreme Court orders it, and basically we are obligated to do it. I don't know how many of these we don't do, because I have a feeling if we fail to pay a claim, even if the court orders it, I mean, I don't know what the consequence is, and Mr. Coonley can maybe comment on that. But I wonder if Senator Anderson has seen this, his comfort level, that sort of thing, because I realize
Senator
it's
Anderson.
late.
Thank you, Madam Chair. I was made aware of this by Senator Latz the first part of April, after the claims hearing had taken place, and he had expressed the fact that this individual had filed this, or his attorneys had filed a claim with the state regarding his situation. I said to Senator Latz at that time, I would want to check with counsel, make sure that he's done all the proper proceedings, all the proper processes that he does, and looking at each of the claims before I made a decision on that, because I felt the way things had led up to the claims committee that we didn't have any other claims coming in. And so I said, and Senator Latz made the statement, well, you're the chair, you can override that decision. And I said, yes, I know, but I count on my counsel and my legal counsel to make sure the process and the proceedings are followed in a way that we would want to see it done in the Senate. So I then, once I left, that was on the Senate floor, I left there, I hadn't seen the claim as far as the name or who the person was. It's just that Senator Latz had made mention of it, and then I would wait and see what Mr. Keenley had to offer.
Thank you, Senator Anderson. Senator Marty.
Yeah, Madam Chair, my comment is again that it's frustrating, but again, I'm not insider of the process, and the chair is saying that he hasn't had a chance to look at it and relies on committee to do it. I find it very frustrating if we do in fact have a state obligation to pay them, to make them wait another year. But I also know it's not, I mean, I'm not sure whether to pursue the amendment, because I get the sense that if the chair is not comfortable with it and hasn't had a chance to review it, I understand that. So I guess what I'll do is withdraw the amendment, but express my great frustration that we do it, and I understand how a process takes time, but I guess I'm not clear how often, enough about the claims process, how often the courts order this and we don't end up paying them. Because anyhow, but I also don't want to make it a bigger mess, because I've seen, we had a problem of it last year and so on, and I don't want to have, I want the Legislative Claims Commission to look at these, Claims Committee to look at these, and I want them to be paid off, but I also, and I'm very frustrated that we make the individual who's already lost 8-some years of his life to wait another year.
I understand, Senator Marty. Have you made a motion to withdraw the 822?
Madam Chair, I'll ask you for guidance on that, because
Well, Senator Marty, I guess what I was thinking, and I talked to Mr. Nauman too, it's good for the record that we have this discussion about this individual. And it's for the record, but I do think we will probably vote to follow the process with Mr. Keenly and the revisor's office. And it's definitely a worthy case, but the timeliness of this is the problem. And I think we'll honor the protocol that comes from the revisor's office. So do appreciate you bringing this forward, though.
And Madam Chair, I
think
will withdraw the amendment, again expressing my frustration, not at you or any person in particular, but that the justice system moves slowly sometimes.
Thank you, Senator Marty. Senator Marty withdraws the A22 amendment. Is there any further questions or comments on Senate file or House file 4670?
Madam Chair?
Senator Anderson, final
Thank you.
comments.
I am very frustrated regarding the situation, what happened in the House, as far as all the claims that we had taken up, that the committee members from the House and the Senate had decided to dissolve and get rid of all the claims that were coming from the DOC, and also with these exoneration claims that the Supreme Court had ruled to pay them off, for us to get them paid off. So I'm very frustrated that we're only doing 3 of the exoneration claims, and that we had all agreed, at least the committee in the whole, had agreed to go forward with the claims as a complete, decided, and resolved situation. But in hindsight, I should say hindsight, but in the last few days, weeks, the House has decided to not pay all the claims, and so these get carried over again for another year to be seen. And so very frustrated with that, but glad we can get rid of these 3 that we do have on the docket. Thank you, Madam Chair.
Thank you, Senator Anderson. Thank you for your service on this committee, too.
Thank you.
Okay. I see no further comments. Senator Ingebrigtsen.
Madam Chair, I move the House File 470 be recommended to pass and placed on general, or, excuse me,
4670.
4670 to be recommended to pass and place on general orders.
On that motion, all those in favor, please say aye.
Aye.
All those opposed, nay. Motion prevails. House file is 460, or 4670 is placed on general orders. Thank you very much, Mr. Keenly.
you,
Members,
Madam Chair.
we are going to go into a recess to the call of the chair. Thank you. Members, we have two more bills on the agenda. We have House File 778. Senator Chamberlain is here with us. It is the sports betting bill. Welcome, Senator Chamberlain.
Good morning. Thank you.
And Senator Chamberlain, you have an author's amendment, the A22-0482. Senator Benson,
Madam Chair, I'll move the author's amendment.
to get the bill in its shape. All those in favor, please say aye. Aye. All those opposed, nay. Motion prevails. The amendment is adopted. Senator Chamberlain.
There is, I believe, one other amendment, a technical amendment to add as well to that. A1. That's the A2.
Madam Chair?
Senator Benson, we are still looking for it. Oh, we don't have it.
I have one labeled SCH0778A1.
The A1 amendment? Okay.
No, it's the A2. It was finished by the tax team.
Senator Benson, I think we're waiting for the A2 amendment. And while we are looking for that, I'd like to welcome Senator Bingham.
There
He's
it
here
was,
too.
Alice.
So is the A2 posted? Yes. The A2 is posted for everyone. Thank you.
Thank you. Thank you.
Senator Chamberlain to the A2 amendment.
Yeah, Madam Chair and members, this, as you see, it's clearly technical, conforming language and lining things up throughout the bill, mobile and racetrack and language, cleans it up and conforms it, aligns it.
I see no questions. Senator Benson.
Madam Chair, I'll move the A2.
Senator Benson moves the A2 amendment. All those in favor, please say aye.
Aye.
All those opposed, nay. Motion prevails. The A2 is adopted. Senator Chamberlain to the bill, please.
Thank you, Madam Chair and members. So we're all familiar with the sports wagering discussion and debate. We've been talking about it for, I don't know, I think it's about 3 years now. The files and the notes are piling up in the office in different forms and boxes. And we've gone through many iterations of this. The House, as you may recall, just recently passed the 778, and that's what we're dealing with here today, and we amended. So it has been discussed quite a bit in different committees, especially in the House, and we have had a lot of discussions in the Senate about this as well. So it's been around a while, a lot of iterations, and we're all very familiar with it now. The bill in front of you, 4 articles. I won't go through each one. There's some highlights to them. The first article is simply definitions, overview, the commissioner's office, what's sports wagering, who can apply for licenses, how the tribes are worked out here, who can bet, all those sorts of things in Article 1. Article 2, I believe, was taxation, and it's fairly straightforward and short. Article 3 is crimes. So, of course, it's pretty standard language in dealing with gambling and violations and fines, what the Commissioner of Public Safety can do, and the Director of Gambling in the state can do, reviewing their authority and reviews and fines, all the way up to criminal charges and penalties related to that. And finally, some conforming amendments for, I believe it was the racetracks in this. Now, a couple of highlights are how this is set up. This particular bill has 2 master licenses. Those are for the tribes. The tribes, 11 tribes in the state came to an agreement that they would have the tribes north of 94 and the tribes south of 94. So internal agreement with them. They did not believe that it was a good idea for every tribe to be a free-for-all. So they wanted to make it so it was more economically viable for them. Some of the tribes are a little smaller than others. So what they did, they entered this internal agreement. The tribes north of 94 would be authorized one master license. The tribes south of 94 would be offered, those are 4 tribes, be offered another master's license. And with that master's license, they can then work with the other tribes and they can get sub-licenses. The commission would issue them licenses, but they'd work within their own framework, contractual framework, to get those licenses issued to the other tribes. In addition to that, the bill also authorizes mobile and brick and mortar licenses for the 2 racetracks in the state, Running Aces and Canterbury Downs. That's right, Canterbury, not Downs, Canterbury. Sorry, where are you, Senator Pratt? Canterbury. Those 2 racetracks could also get a license to operate mobile and also brick and mortar. The tax on sports wagering would be on the net revenue. If you have let's just for sake of argument, for example, here is you have a $100 bet, and what you end up with is, I'll do it another way. Typically, what you have is a setup where, for example, Iowa just passed $1 billion wagering. So you have the gross handle, the gross wagering is $1 billion. It's all bets placed, sports bets placed. So the average is that the operators end up with about 10% after all the prizes are paid out. So you have a net, $1 billion gross, you end up with $100 million net, which is about 10% is usually where it falls. Now that net revenue is what would be taxed, and that's in this bill at 10%. So you have the net revenue at $100 million would be taxed 10%, so you get about $10 million. Was never intended, was never believed that this would be a huge moneymaker. Some people thought it would. I have never tried to sell that to anybody. You can't have the tax too high. People will not do it. They'll just go somewhere else. Can't have it too low. You have to have some money, right? So I think, and then the distribution. Right now, the distribution is set up 1/3 to charitable gaming, 1/3 to promote events, sporting events in the state of Minnesota, and then 1/3 to mental health. So that's how those revenues would be split up. It also talks about licensing periods and renewals. I think you might have a summary in your packets, and on the second page, it kind of goes over the renewals and licenses. You'll have the operators, which would be the tribes and the racetracks, and then I believe how it's the language in here, what we would consider bookmakers. I think those are labeled here sports betting suppliers, if I think that is the correct. I'll get a nod there. So there's a lot of ways to look at that, but that's what you would call the bookmaker. They're the sports betting supplier. They set the odds and all odds and the costs and the prices. Then, of course, in the bill, you can see, and in the summary, there are different licenses as well. Vendors, supplier, the applications, and so on and so forth. Final 2 notes is that part of the challenge here, I mean, with this, as you are all aware, there are a lot of challenges and a lot of obstacles to get around and a lot of people to talk to. But you have to have a viable market. So I talked earlier about the tax can't be too high. But you also have the viable market in the sense of choices for the consumer. We can't just have maybe 2 licenses in the state and maybe hope for others. You need to have a healthy market of different odds and different prices. In other words, you need a variety and a number of bookmakers, so you have different odds and different prices available to consumers. If you have just one or maybe two, you may not get that. So it's important for the consumer and to have a good product, something that's viable and workable, to have competition in the state for the products. Now, finally, and the happy note, this is all happy, I think. It's good news, at least from my perspective. It's entertainment, folks. It's legal entertainment. The state of Minnesota, we gamble at charitable gaming is about $5 billion alone in this state. I don't know if that accounts for, I haven't looked at the numbers lately. We could later if someone wanted to. But I don't think that includes our lottery, and that doesn't include the casinos. So we may think that's crazy and it's terrible. Well, perhaps, maybe, yep. But it's entertainment. It's legal. It's safe. It's fun, and a lot of people engage in this activity. So I've been trying to do it for a few years because of that. It's entertainment, legal, fun. A lot of people like to partake. It's safe. So with that, I'll stop talking and let people ask questions.
Thank you, Senator Chamberlain. Actually, I think we'll turn to Ms. James, if she can go through a brief walkthrough and fill in the blanks.
Madam Chair and members, the bill regulates sports betting through the Commissioner of Public Safety. The Commissioner is authorized to delegate responsibilities to the Division of Alcohol and Gambling Enforcement. The bill establishes licensing for the entities that will deliver sports betting. Senator Chamberlain has described the significant component, which is that there are 2 master licenses, and then there are 11 mobile sports betting licenses, which also go to tribes. The master sports licenses licensees are charged with organizing the activities of the 11 mobile sports betting licensees that are tribes. And then in addition, there are licenses to the 2 racetracks, and they're authorized to offer sports betting on site at the racetracks and also mobile sports betting. In addition, there are several other kinds of entities that support the offering of sports betting, and there's structures for licensing those entities too. The governor is also authorized to negotiate with the tribes on compacts to offer sports betting on tribal lands. The kinds of events that may be wagered on include college and pro athletic events, esports, the draft of players into professional sports teams, and also awards on arts and sports. The Commissioner of Public Safety has the authorization to approve the kinds of events and also the types of wagers that can be offered. And then sections 14 through 23 of the bill are under a sort of broad umbrella of protections and accountability and reporting on activities. There's a prohibition on certain advertising that targets people under 21 and also people who are excluded from wagering. There's an option for people to put themselves voluntarily on an exclusion list where they will then be prohibited from wagering. Also, legal guardians can put people on that list, and people can specify the amount of time that they would like to be on the list. There's also provision that specifies that it is the mobile sports betting operators and racetracks that are responsible for the risk of loss of wagers. And there are protections for those entities to maintain cash reserves and also to have security for the financial interests of wagers. There's a requirement for integrity marketing monitoring, which will look for unusual sports betting activity. There's provisions for the Commissioner of Public Safety to be able to inspect and audit the financial records of institutions offering sports betting. And then there's reporting to the legislature on the commissioner's activities in regulating sports betting and also in the licensing activity. Data protections for individuals, for the data that's on individuals is in section 22. And then the last section in Article 1, section 23 precludes political subdivisions from requiring a license or imposing taxes on sports betting.
Thank you, Ms. James. Do we have any questions on that? Actually, I think I'd like to go to Mr. Willems and step us through the revenue estimate. And then we can, don't go far, Ms. James. Is Mr. Willems around? No? There he is. Okay, very good. Good morning, Mr. Willems.
Good morning, Madam Chair and committee members. My name is Jay Whelms, fiscal analyst for the Taxes Committee. The revenue estimate before you, dated May 19th, reflects estimate provided by Department of Revenue Tax Research Division, shows that the general fund impact beginning in FY24 for sports betting net revenue received after June 30th, 2023 is revenue increase of $5.6 million in FY24 and $12.8 million in FY25. I think there's a couple things to note here. The FY24 number reflects 11 out of 12 months of collection, but that number is expected to grow in addition outside of the forecast period. So the estimate here doesn't list that amount, but some of the estimates we've seen from other states and based on this tax structure indicate that it could be anywhere from 20 to 30 million in the out years. And, you know, it's a function of the rate and then the base. And of course, you know, what we're looking at is the total all cash and cash equivalents received in a month, and less cash paid out by winnings and any non-cash prizes paid out. And then any deductions for excise taxes, including the federal excise tax on gambling.
Thank you, Mr. Willems.
He said general fund. I think it's the special revenue.
Mr. Nauman.
Members, I just want to clarify, I think the revenues accrue to the special revenue fund. Okay.
Mr. Willems.
Excuse me, sorry. Yes, to special revenue fund as indicated, 1/3 as indicated prior for human services, 1/3 for lawful gambling payments to charitable gambling organizations, and then 1/3 for the sports awareness accounts. Sorry, apologies for that. Old habits die hard on the general fund.
Mr. Willems, before you go, I do have a question either for you or Mr. Senator Chamberlain. I know you've been working on this for many years. Have you seen any correlation of other types of gambling that have declined with revenue because of sports betting? I'm thinking specifically of the e-pull tabs and the state and reserve account.
Thank you, Madam Chair and committee members. I think there, in some of the economic literature, I've seen that issue discussed, but I wouldn't say that I've done enough research to comment on that aspect of it, but I think it's certainly an issue area that a lot of people ask about, and you know, the revenue estimate doesn't speak to that, doesn't score any interactions from that,
Okay.
but it's a valid question.
Thank you, Mr. Willems. I hate to put you on the spot. And Senator Chamberlain, I know we've had discussions about this because of the interest of keeping the state and reserve account solid. And I think we're talking about a different demographic. Is that correct?
Yeah, I would say two things. It's, as Mr. Williams had stated, it's certainly possible, and I wouldn't try to deny that it would happen, you know, kind of switching a little bit. But as you mentioned, and it is a different demographic and a different type of betting, right? But that's not to say that it won't have some impact, but I think it's mitigated by just that, the demographics.
Okay, thank you. Any questions for Mr. Willems before we let him go? Okay, thank you so much, Mr. Willems. And I think we'll go to Mr. Backus to review the penalties. Good morning, Mr. Backus.
Morning, Madam Chair and members. Can you hear me?
Sure can.
Okay. So, yeah, I'll go through Article 3, which is entitled Crimes Related to Sports Wagering, and I'll just do a kind of a big picture overview. Let me know if you want more details or a section-by-section overview.
Mr. Backus, you may have to get adjust that microphone a little bit better.
This is much better.
That's much better, thank you.
So Article 3 contains the criminal penalties for the bill. It creates new crimes for bets placed by unauthorized persons. Unauthorized persons are underage persons, those under 21 years of age, participants in the sporting event, individuals associated with the Department of Public Safety, licensees or employees of licensees, and those with non-public information. It also criminalizes bets received by licensees or employees of licensees from unauthorized persons, and also prohibits the sale of private data on individuals collected through sports wagering. The article makes a series of conforming changes to the criminal code's existing gambling crimes to reflect the new legalization of sports betting. It creates a parallel crime of unauthorized sports betting in the criminal code to reflect persons who place illegal bets on sporting events with unlicensed persons. So if you place bets with licensed persons that are illegal, that's already covered, and this covers the other side of it. And then finally, the provision adds a new felony in the criminal code for bribing a participant in a sporting event to either influence the event's outcome or the participant's performance, or for a participant to accept a bribe to do that.
Thank you, Mr. Backus. Are there any questions on this particular Article 3? Yes, Senator Benson? No? No? Okay, thank you. Senator Marty.
Thank you, Madam Chair and Mr. Backus. Just looking at on page 33, the unauthorized acceptance of wagers. In other words, if one of the sponsors of the gambling accepts a wager knowing that the wager is made in violation of subdivision 4 is guilty of a crime, what if they don't know it is and they're not really making a great effort to find out?
Mr. Backus.
Madam Chair and Senator Marty, I would, the crime requires that essentially the wager be accepted knowing that the wager was made in violation. So I think you would have to prove that mental state, and if you couldn't prove it, you wouldn't be able to get a conviction.
Senator Marty.
So, Madam Chair, Mr. Backus, supposing a 16-year-old is illegally betting under this, and they accept a wager from a person, and they didn't know who the person was, and obviously people who are trying to do it illegally are trying to cover their tracks and so on. So how much is there any obligation for the acceptor of the person accepting the wager? What is there any obligation they have to find out? I'm just curious how extensively this is. It seems to me that I could accept a bet from a 16-year-old, and these are big operations, and I could accept such a bet, and well, I didn't know they were under 16. They were under 21. Is there any penalty for that?
Mr. Backus.
Madam Chair and Senator Marty, that's addressed in a different provision. It provides that essentially a licensed person who accepts a wager by an underage person, it's a gross misdemeanor, and there's language about what would be essentially proper proof of age, and it's a crime for the underage person to misrepresent their age. A lot of this language is taken from current law on underage consumption of alcohol, things like that. So I think a lot of those concepts would apply to this as well.
So,
Senator Marty.
Madam Chair, so for the underage one, we're using the same standard as for alcohol, but for the unauthorized wagers, other than the person under 21, there's no particular obligation for them to invest. There are no standards for what they have to do to, or are there standards, I guess I should ask.
Mr. Backus.
Madam Chair and Senator Marty, actually, yes, I'm sorry. Part of the issue here, too, is that, the bill's somewhat bifurcated in terms of these articles. So I'm familiar with what's in my article, so to speak. Ms. James just pointed out that apparently there's language on page 19, looks like 19.6, where a a racetrack, a mobile sports betting operator, et cetera, shall verify a person's age and identity before allowing the person to place a wager. Yeah, I don't know if there's anything else in there regarding those other types of wagers you were discussing in terms of, ensuring that the person isn't unauthorized. I think there'd be a natural interest in, making sure one is not violating the law. So I think if I were doing it, I would try to be, pretty careful. But I think it might go also to training of the licensees and the employees as well.
Senator Ingebrigtsen?
Madam Chair, that's quite intriguing here. I'm just wondering if anybody can tell me how they're going to follow up on that. How does the person on the other end know the age? How do they confirm the age? Is there technology there to do as such? That seems to be kind of a real tough issue. When you're talking about minor in possession or things like that, usually you catch them in the act, but if it's online, I'm just wondering how that would work.
You would like to take a stab at that, Senator Chamberlain?
I'm no expert in that area, Madam Chair and Senator Ingebrigtsen, but there are steps you can take to do age verification online. So I can't be too specific about that, but I know there are processes they can use to do that, just like you would with a lot of other, similar situations, making purchases online with other things as well.
Senator Ingebrigtsen? Yeah, good.
Yeah, thank you, Mr. Chair, Madam Chair. And I'm being told that possibly you could take a picture of the license, but I think that's going to be kind of cumbersome thing too. That's easy enough to do and then hand it off to your 16-year-old brother, and they can do the sports betting. So maybe it's the cop in me, Senator Chamberlain. I'm just wondering what kind of a nightmare that's going to be.
Okay. Thank you, Senator Ingebrigtsen. Senator Kiffmeyer.
Yes, I have a question on page 26, section 24. Senator Chamberlain says here, the governor or the governor's designated representative shall negotiate in good faith new tribal state compacts regulating the conduct of Class 3 sports betting. I recall previously this was a negotiated thing as well. Ended up being in perpetuity and shutting out the rest of Minnesotans. So here now we have another negotiating. So could you explain that a little bit more, Senator Chamberlain, what all that is about?
Senator Chamberlain.
Thank you, Madam Chair and Senator Kiffmeyer. So, and if I miss a gap here, I'll defer to Ms. James again. But my understanding of federal tribal gaming law is that the state first has to make it legal, right? Ultimately, these are semi-sovereign nations, and the oversight is the federal government. But before they engage, they still are within the state. So before they could engage in, for example, the gambling and the gaming they have now at the casinos, first we make it legal in the state, and then if they want to participate in that, then you have to negotiate a compact. So the compact is, I'm going to put on my glasses so I can see it better. The compact would be required to, if they wanted to engage in this. Now, there have been, and Minnesota is unique, every state's a little different. I believe Michigan, they had a little bit different setup, and they didn't have to renegotiate another compact. And we thought about that, and that still might be the case, that one would not have to be redone or it could be worked into the existing compact. So, summarize that again. first, the state has to make it legal, and then if the tribes want to engage in the activity, then the state enters into a compact by federal law with the tribes to do that. And what happens in the negotiations, you're right. I mean, who knows where that can go. But, that's one reason we believe it's important as well to have the tracks involved in this as we go forward, to have to provide a solid product for the consumers across the board and make it available in different venues and different places for the consumers. So the compact is required, in short, by the federal government. And some states, like Michigan, I think they were able to roll it in and not redo a compact. But in short, it would be required.
Senator Kiffmeyer.
Yeah, thank you, Madam Chair. Well, I appreciate that information, but it brings up a lot more questions in regards to, there are no limits on this. It says the governor would have sole authority here to negotiate. Sole authority. This did not go well for Minnesota the last time this happened. And so to see this going on right now, much less just the whole basic expansion of gambling in general, there are issues with that. But now here we have this that I think is probably as much concerning as the whole thing. And I was also questioning about shall not be modified to accommodate sports betting. So there's a lot of loaded language in here. It only takes up 4 lines. But I think this is really not good for Minnesota, just on this basis alone.
Madam Chair.
Senator Chamberlain.
Right, so line 2625, again, long story, but line 2625 is to provide assurances that they don't go on the old compact and try to undo the old compact. But this bill moves on. There are changes and adjustments that need to be made into this bill that we couldn't get today. For example, some things for, say, the charitable gaming and also for prevention of gambling and Gamblers Anonymous sorts of things. So there are some things that would have to be, still need to be fixed and adjusted and negotiated to get this right. And I would say that the compact language might be one of those, but in short, the federal law requires a compact to be negotiated. And I will admit that maybe we can defer to Ms. James on this. She might have more than I do, and how those negotiations are required to be set up. So maybe does Ms. James have information on particular how that would be arranged?
Ms. James.
Madam Chair and members, the bill does not specify any particular parameters around that. It would need to fall within what we've made legal in the state, but beyond that, there's no parameters around what's negotiated in the compacts. The original compacts did not require payments to the state, and so that is the reason that the original compacts would not, that's the reason that the language is in here that precludes modification of the original compacts, because folks don't want those changed, and so this requires new compacts.
Thank you, Ms. James. Senator Pratt.
Thank you, Madam Chair and Senator Chamberlain. This might be a question for Ms. James. So I looked at the cross-reference, and under subdivision 2, it says if the governor appoints designees to negotiate under their subdivision, the designees must include at least 2 members of the Senate and 2 members of the House, 2 of whom must be the chairs of the Senate and House representative standing committees with jurisdiction over gambling policy. So I guess my question is, if the governor does not do this personally, right, does that then require these legislative leaders to be those designees?
Ms. James.
Madam Chair and members, I'm not familiar with what Senator Pratt has, the cross-reference that he's described, or the,
Senator Pratt.
So it's 3.9221, and I'm just looking at subdivision 2 negotiations authorized.
Ms. James.
Madam Chair, I'll pull that up.
Eric, do you want to pull it up in the book for her?
She'll be faster than I will.
Madam Chair and members, yes, I believe Senator Pratt is correct that this cross-reference to Section 3.9221 implicates everything in 3.9221. And that would mean that if the governor chooses to appoint designees, they would be 2 members of the Senate and 2 members of the House.
Senator Pratt.
Thank you, Madam Chair. Ms. James, under everything else that we've done, would a staff member or a commissioner be a designee under this definition?
Ms. James.
Madam Chair and members, 3.9221 looks to me like if any designees are appointed to do the work, it would need to be the members of the Senate and the House.
Senator Pratt.
Thank you, Madam Chair. I'm just trying to clarify that the commissioners or the governor's staff would qualify as designees if the governor didn't do it personally. They can't act as the governor.
Ms. James.
Madam Chair and members, my reading of 3.9221 is that the governor can appoint designees, two of whom have to be members of the legislature, but then there isn't a limit on the number of representatives that the governor can appoint. So there could be other people who are also designees.
Senator Pratt. Yep. Okay. Very good.
Madam Chair, to this point,
Do you have anything to confirm? No. Okay. Senator Champion.
thank you, Madam Chair. Ms. James, looking at the same provision, can you explain to me or at least share with us how there's the interplay in 26.22 all the way through 26.25 where it says shall negotiate in good faith new tribal state compacts regulating the conduct of Class 3 sports betting, but then on the last line it says shall not be modified, yada, 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 compacts shall not be modified to accommodate sports betting. Can you help me understand how the interplay of those two things work, especially if this whole thing is about sports betting, but then it says any new compacts cannot modify those compacts to accommodate sports betting?
Ms. James.
Madam Chair and members, that last sentence, compacts in effect on January 1st, 2022. So that's the existing compacts that can't be modified to accommodate sports betting. But the first sentence authorizes new compacts for sports betting.
Okay. Senator Champion. Good.
I have no other questions to this point, but I do have questions,
Sure,
Madam Chair.
absolutely. Okay. Very good. I don't see any other questions for you at this time, Ms. James. I think we'll have Ms. Pollock, if she's available, to go over the tax portion of the bill. I believe that's Article 2. Welcome, Ms. Pollock. Just a review on the, I believe it's Article 2, the taxation of the sports betting. Good.
Madam Chair and members, yes, the Article 2 is the taxation article, and some of this will be repetitive there would be a 10% tax imposed on sports wagering net revenue, which is defined as all cash and cash equivalents received in a month by a mobile sports betting operator and a racetrack for wagers on sporting events. And that would be less cash paid out as winnings, the cash equivalent of non-cash prizes paid out as winnings, and all excise taxes that are imposed under federal law. The tax is imposed both on wagers placed online or through a mobile application or in person at a racetrack. And the 10% tax on sports wagering net revenue is in lieu of any income, sales, or charitable gambling taxes.
Madam Chair, is the microphone on? Because I think people are having trouble online.
Oh, I'm sorry. Should I start over?
There he goes. Thank you, Senator Lucas Franzen. No, you can continue, Ms. Pollock.
Madam Chair, the only other comments I would have are to the three deposits of, or three allocations of the sports wagering net revenue, which I believe Mr. Wilms discussed.
Very good. Any questions for Ms. Pollock?
Madam
Senator
Chair, thank you. So I just want to be clear, this is on net. So that would be net of the machines that are used, employees that are paid, all prizes paid out. Is that a correct
Ms. Pollock?
understanding? So normal calculation of net income.
Ms. Pollock?
Madam Chair and Senator Benson, partially. So this would not apply to any otherwise, and expenses that would be otherwise deductible for federal income tax purposes. It only applies to cash receipts and cash equivalents that would be received by the mobile sports betting operator or the racetrack.
Thank you, Madam
Senator
Chair.
Benson, yep, okay. Very good. Don't see any further questions on that area. Thank you, Ms. Pollock. Appreciate it. Okay, let's open up for discussions. Senator Kiffmeyer.
Well, Madam Chair, I just wanted to ask another question on the language itself. On page 37, it has an unusual language here, which is, whoever makes a bet on a sporting event with a person who is not licensed, is guilty of a misdemeanor. If they make a bet on a sporting event with a person who is not licensed to engage, is guilty of a gross misdemeanor. We're going to be, I think at the family get-together sometimes that have some things going on. So this would make criminals of a whole bunch of people. That's very broad, very, again, a lot about this bill on the issue of gambling in general, but then this language. Thank you, Madam Chair.
Thank you, Senator Kiffmeyer. Senator
Madam
Chamberlain.
Chair?
Senator Chamberlain.
Yeah, Madam Chair and Senator Kiffmeyer, I'm going to defer to Mr. Backus, but there is an exclusion. This does not include those sorts of family wagers. But I'll defer to Mr. Backus for the particular clause or subdivision that's under.
Mr. Backus.
Madam Chair and members, that's correct. I think it's a couple places in the delete everything, but it wouldn't apply to those type of social bets, private social bets.
Senator Kiffmeyer.
What if they're not related? What if, there are all kinds of times where these things, like it was mentioned, a social situation, but I'm concerned that we're going to have people who have a friendly kind of activity going on that now could be at risk of some serious criminal consequences.
Senator Chamberlain.
Madam Chair, Senator Kiffmeyer, well, if they get to the point where they're wearing the hat with a visor and they got a sharpened pencil in their hand and they're in the back room and they're taking bets, which they're probably doing today anyway, then they are a sports wagering operation. They should be licensed. But the intent is certainly not to go after Susie and Johnny or Uncle Joe putting a $10 bet on, on which turtle's going to cross the line first. But in Longville, turtle races, that's not what this is intended to be, not at all. But it is intended to, if somebody starts to run a large operation outside the normal parameters of the law, then yeah, that would be a violation of law and they'd be subject to penalties. Because now you're getting into a large operation making profits off it. And that's kind of the difference, right? You can't be making, if your intent is to make large profits off of it and you have a lot of customer base, then that's out of line. But if it's just between family members or friends occasionally, just like garage sales aren't subject to income tax.
Thank you, Senator Chamberlain. Mr. Bonner.
Madam Chair, and this might be helpful, but the bill is geared toward the regulation of sports betting, and sports betting is defined on page 4, lines 26 and 27, not to include a private social bet that is referenced in section 609.75 sub 3 of the statutes. And this language might be helpful. I read that to include, or rather to exclude, a private social bet not part of or incidental to organized, commercialized, or systematic gambling. It's basically the same thing Senator Chamberlain is saying, but how it's written in the statutes. I think that's correct.
Thank you. Very good. Who's got it? Senator Marty.
Thank you, Madam Chair. I appreciate that, Mr. Botter, and I guess I have a little more question about that. What Senator Kiffmeyer is pointing to, I mean, I keep thinking we're talking about legalizing sports betting here. There's a lot of sports betting going on now in what we would call these social bets. I think here at the Senate and plenty of other places, I don't know many places that don't have Final Four pools. That's sports betting, but according to this definition, Mr. Bonner, you're saying that does not count as this. In other words, this bill is not legalizing sports betting. It's continuing to treat those private bets between people, and somebody's not profiting from it other than winning a bet. That already exists. That's not being changed by this, you're saying. So what we're talking about is somebody else coming in and managing and profiting off the bets. Is that the distinction? And are all of the things that I think most of us would consider sports betting not touched by this bill, period?
Mr. Bonner.
Madam Chair and Senator Marty, again, the way the law is written right now and what is preserved, I think in this delete everything amendment is the exclusion of a private social bet that is not part of or incidental to organized, commercialized, or systematic gambling. And what you're describing, to the extent that there's sort of a profit that accrues to the person organizing the betting, maybe separate from the wager itself, would certainly not fit the definition of a social bet. But I think I'll defer to the experts. Mr. Backus or Ms. James might have a view of whether something like a Final Four betting pool would fit within that definition. That's probably going a little further afield.
Mr. Backus.
Yes, Madam Chair and members. Again, as Mr. Bodden said, I think that's the language. Currently, you can have private social bets on sporting events, but it can't be incidental to organized, commercialized, or systematic gambling, which, those are terms that you have to, the court or a judge has to construe. So, I mean, like this bill legalizes more, again, the organized, systemic type of gambling that are not private social events under current law.
Very good. Senator Marty.
So, Madam Chair, Mr. Backus, on page 4, line 26, I haven't looked at the cross-reference, 609.75 sub 3, clause 5, is not sports betting. In effect, what a lot of us would see as sports betting is not sports betting under this and would not be made illegal, would not be made legal, it would just be where it is now. This bill touches only when somebody is coming in and you and Mr. Bodden are both saying that you don't think this would make that subject to any further penalties in this bill because it's clearly not, even if it's a office-wide pool in a big organization, because as long as somebody is not profiting outside of who wins the pool.
Mr. Backus.
Madam Chair and Senator Marty, I don't know that I would say that exactly. If you're talking about an NCAA pool, I think you have to look at whether how organized, how commercialized, or how systemic it is. I know that that's been, people have asked about that in the past. I don't exactly know off the top of my head whether that moves away from what is a private social bet. But clearly under current law, two friends or whatever can bet, whatever, $20 or $100 on the Vikings. That would be a private social bet under current law.
Senator Marty.
Madam Chair, I guess I'm wondering on this because when Senator Kiffmeyer raised that point, it just struck me as a bill on legalizing sports betting. If it's taking away some existing stuff here, in effect, it's criminalizing something that I don't think anybody has seen as criminal. I mean, maybe it is criminal, I don't know, but I just see people openly doing it, including elected officials talking about how various, usually Final Four type of pools. I guess I want to know because this is putting pretty serious penalties on for somebody who might be doing something that most Minnesotans, I think, would call sports betting. And instead of legalizing it, would be taking those folks and criminalizing them when we're actually talking about somebody profiting off of those betting pools and so on.
Madam Chair.
Senator Chamberlain.
Yeah, I mean, this is, most states in the country are doing this now, and there's, in my reading and in what I have seen and heard, that's simply not the case. Office pools are not, they weren't illegal, and they won't be illegal under this. The intent here is, as was mentioned earlier, an organized, systematic, commercialized system process for taking sports wagering bets and profiting. That's what this defines. What Senator Marty says, yeah, if you're betting on the March Madness in the pool, that is betting, and you're betting on the outcome of a sporting event. Yes, technically it is. So the language in here makes sure that that is not criminalized. Nobody's intending to criminalize that. It won't be criminalized. Nobody that I know has been prosecuted within the United States of America ever for doing sports pools, the office pools. So it simply is not the case. It won't happen, and it won't happen under this with the language here as well. So it won't make those illegal in any way, shape, or form.
Thank you, Madam Chair.
Senator
It would be ironic if it was, because, again, we're talking about legalizing sports betting and something I think a lot of people consider sports betting. Again, not having reviewed this carefully and just relying on what we're hearing from Senate Counsel and so on, it sounds like it would not be I think this deserves a little more hearing on that kind of issue, but it's not, we should be clear that this is not affecting what most people are doing right now in sports betting.
Thank you, Senator Marty. Senator Champion?
Thank you, Madam Chair. Before I get to my ultimate question, Senator Chamberlain, along the lines of what Senator Marty was proposing, or at least asking you to react to, and you indicated that it's your understanding that no one would interpret it that way, have you had an opportunity to engage any other prosecutors or anyone else in order to get their viewpoint as to how they would interpret this language?
Senator Chamberlain.
Madam Chair, Senator Champion, I have not spoken to prosecutors on this, no.
All right.
Senator Champion?
Thank you. And Senator Chamberlain, a couple questions I have is that, just getting to some of the gambling issues, you realize, or I believe that you understand, that low-income Minnesotans are at the highest risk of becoming problem gamblers, and that black Minnesotans were more than twice as likely as white Minnesotans to be problem gamblers. And I'm sure that you've seen that all these studies also show that poor neighborhoods have the highest risk of being problem gamblers. So, and then that addiction is, usually twice as likely in neighborhoods with concentrated poverty from those, than in those with the highest concentration of poverty, right? So my question is, what in this bill would sort of help if it goes forward with addiction? Because I see that money is being spent on mental health, it's been spent in other places and spaces, but can you share with me how this bill would address any addiction?
Thank you, Madam Chair. Thank you, Senator Champion. So, right, and I mentioned earlier that this bill moves forward, there are some changes that still need to be made. Admittedly, this came from the House and things changed quickly. So that's why we have a committee process to chat about these things more, to make sure we get it right. Now, the bill that I had originally addressed that, and part of the proceeds were going to go directly to gambling awareness and problem gamblers. So this bill does not have that in here. It has some other minor protection, but it doesn't have any extra supports in there for that. And I'll just say again, our original proposal from the Senate had that in there. And I had met with, sorry, I can't remember her name now, the lady who heads up the organization in the state. I met with her on a few occasions and with Catholic Conference to discuss that issue. So, bill moves forward. I've assured Catholic Conference, and I will assure all of you that that will be in there, either in some different language for prevention. We moved the age of 21 to be legal, and I would like to see more money go to Gamblers Anonymous. When I talked to her, they only get $500,000 a year, and she says she usually has to fight for that through the charitable organizations. So I would like to see a few more things in here for that, Senator Champion, and I would like to also add in the additional funds for that.
Madam Chair, I noticed that under the distribution of funds that it has some language around compulsive gambling treatment, but I have some concerns about the connection between communities of color and this, and so thank you for your honesty there, Senator Chamberlain. My next question is, how did you come up with, in Article 2, page 28.21, the net revenue tax by 10%, and then you talk about how that money would be allocated a third for Minnesota events, and you talk about Final Four and others, and then you also talk about the third for mental health, and then you have a third for gambling organizations, namely charitable organizations. How did you come up with that being the way to distribute this revenue?
Well, Madam Chair and Senator Champion, thanks for bringing it up. That has been, of all the pieces of this proposal, the distribution of funds has been the most interesting. From the little background, right, from the day that the Supreme Court found this federal law unconstitutional, and I began speaking with a colleague in the House about it, a lot of people jumped on it thinking that this was going to be a big moneymaker for the state. That was never going to be the case, and I never sold that as the case, just as a little background. But now the distribution of funds, and the updated revenue notice, as you see, only has about 12 million as it shifts out in later years. In the end, I think it'd be 10 to 20 million a year in revenue directly from sports wagering. So the distributions aren't going to be huge, but they can be significant. I think it makes a significant dent in, I think a few $1 million a year is significant for mental health. And for charitable gaming, I don't know how much that is, probably not that much compared to what they'd be better off with the tax reform on that side, but it's still something. So as far as 1/3 and 1/3 and 1/3, this area has changed several times. And like I said, this moved fairly rapidly from the House, so this change was just made in the last couple of days, and I was not necessarily involved in that particular language. I was out of the picture for a day or two, incommunicado. So I didn't have input on that piece. But like I said, the original bill, ours here, had a distribution for them. So I suppose it just was cut up that way because it made it easy because there were 3 pieces, but it can be redone. And I made a commitment, the bill moves on, it will be redone, and we will make sure that the appropriate agency gets more money and gets it directly. And when you get more money, at $500,000 a year, they can't do hardly anything, right? So if they get twice that much, or maybe $1 million, they can do a lot more advertising and outreach and that sort of thing. So that's a long story, but I thought the background, and it's one of the most interesting parts of the bill.
And Madam Chair, if I could self-correct myself, the information where I was talking about the gambling stuff, your amendment took that out. And so I'd like to self-correct myself there. Senator Chamberlain, have you had an opportunity to talk with the tribes and get some input from them as to your amendment? And if so, what has been the tribe's position? And that's one question. And secondly, you would agree with me that the way that your amendment structures this bill, it expands gaming and it expands it into more of a commercial reach when you think in terms of the racetracks and those things. Am I accurate as it pertains to that? And can you expand and share with us why?
Senator Chamberlain.
Thank you, Madam Chair. Senator Champion. Yeah, I'm not going to sit here and say it doesn't expand gambling. It certainly does legalize that part of gambling, which a lot of people are saying already exists anyway, and they go across the borders to Wisconsin and Iowa certainly to participate, and they already have the applications. They might be doing it now within the state, not necessarily legally, but they are. So yes, it would expand it by law, but some would argue that it's already taking place, and what this does, it puts guardrails and regulation around it to control it, monitor it, watch it, and perhaps address some of the gambling problems some people might have. So yes, it does. I'm sorry, what was the first question again, Senator?
Madam Chair, my first question was whether you've had any conversation with the tribes about the language that you put forward, because it appears that this language and expansion of gaming seems to, at least maybe you can react to, whether that infringes upon the treaties that we have with the tribes.
Thank you, Senator Champion and Madam Chair. So we have, myself and others, so both directly and indirectly, conversations with the tribes through some direct conversations or through their representatives or through other legislators who have been speaking to them as well. So yes, over the last 3 years, many contacts and conversations about it. Secondly, yes, the tribes are trying to protect their livelihood, and I fully support that. I fully support their business model, and I have been a champion of supporting that business model for years. You might recall a few years ago that the former commissioner tried to put it on gas pumps and ATMs, and that upset a lot of people for a lot of different reasons. So we were interested in protecting their business model, still am. That being said, I had mentioned earlier, part of doing this, if it's going to work and being a good product, we have to have we have to have competition. And the way it's set up, I don't know that we could get that with just the tribe, because they have argued that they don't want to be in competition with each other, and that's why they created their own internal contract. And some of their tribes are small, so they couldn't afford to kick it up. So we have talked with them off and on for 3 years. We want to make sure that they're good with it and they're happy with it. I've always maintained that it will be good for their business as well. I've been to Hinckley, and they, I don't know if you've been up there, but they redid one end of their facility. To me, I looked at that and I said, there's a sports book. Yeah, I mean, it's a sport, a little bowling alley in the back and TVs all over the place. Very comfortable. So I think it's good for their business model. So I have been told by them that they would like to see something get done as well. So they want to get something done. We want to work with them. We will make sure their product and their business model is protected, and that we can work together to do that, to provide a good, solid product for consumers in a regulated market that protects people and gets more protections for those who might have a problem with gambling. So that's a long answer, but the short answer is yes. We've worked with them. We want to protect it, have a good product, and protect people at the same time.
Madam Chair, my last question.
Before Senator Chamberlain, I just want to remind folks that we do have session at 11, and we do have the state employee contracts that we'll probably have to come back this afternoon. So, Senator Chamberlain.
Thank you, Madam Chair. I think this is my last question. So it sounds like, Senator Chamberlain, that you respect the tribes and their ability to look at their business model and decide what they want, and it also sounds like they're not supportive of your language because it expands and it expands outside their control. But my other question is, can you share with the committee what committees did this bill go through? Because it sounds like there's a lot of work that needs to be done and there's a lot of consideration. And I think I heard you say that there's been a lot of vetting of this bill, but I'm not quite sure if I heard that correctly because I was sort of messing around with my papers. So I wanted to just ask you, what other committees have this bill gone through?
Senator Chamberlain.
Thank you, Madam Chair and Senator Champion. So just to back up a second, I've been told directly, face-to-face, by a tribal representative they'd like to get it done. And I've assured them through the whole process that we'll protect their business model. My original draft had the tribes having master licenses, the 2 master licenses, then they may enter in agreements with the other tribes and they're set in their area, north or south of 94, either side of 94, but they would have to have right of first refusal, give right of first refusal to the 2 tracks, meaning that the tracks would have to be in part of that process, and they'd have to agree to terms no less favorable than they would with the other tribes, but it would ultimately be a compromise and allow them to have some oversight and some control of the ultimate product. So we've been working with the tribes to find a compromise. They want to have something done. We do too. Good product for the customers, and we are hopeful that they will do just that. Now, what committees? This has been in discussion now for 3 years. It's been in our state gov committee twice, and it has been, this particular language has been through the House committee process as well. So there's no secrets here. It's been vetted here. It's been vetted on the other side, in the other body as well, and that's pretty much why we took their language, because they had it worked out in final tweaks that people were happy with. It passed the House, but the House had exclusivity to the tribes, and that doesn't work for a business model for the state and the product.
Senator Chamberlain.
Thank you, Madam Chair. Senator Chamberlain, but I recognize that there's been some discussions, there's lots of discussions that's always floating around this wonderful facilities, but it sounds like the language that the tribes were comfortable with is the language that you ended up deleting. Because it's my understanding that the House had some language that they were okay with, and then with your amendments, it sort of deleted the House version of things. Now, perhaps I'm wrong, but that's my understanding. And so it just seems interesting to me, unless you could correct me if I'm wrong, that if there's the language that they thought would work for their House, for their business model, it was vetted over in the House, and it appears to be the language that was acceptable but then now your bill and your amendment seems to delete that language and adds in another component that seems to conflict with their business model. I don't know if I'm right or wrong. If you could expand on that, and thank you, Madam Chair, for being patient, and I'll be quiet after this.
Senator Chamberlain.
Madam Chair, Senator Champion, as I mentioned before, and I have said all along, we are happy to work with the tribes. We have been working with the tribes. They have said they wanted to get something done. And I've had different conversations that they were comfortable with the master's license setup. But the last thing I have mentioned over and over again is that we need to have a good product for the customers that makes it viable and successful. We have to have and protects the interests of all parties, viable, successful for the consumers, and protects all parties. It has to go beyond just the tribes, because there's no guarantee that there'll be competition and a good product if we just have one or two. Certainly, if we only have one bookmaker in the state that signs a contract with both master license, well, then you only have one bookmaker, one number, one price. And that's not going to be a product that we can work with. So that is one of the concerns, too.
As I look at it, Senator Chamberlain, and as we all know around this table, a massive, complicated bill like this takes all stakeholders around the table to compromise and get to a bill that is workable for all parties. And I think that's the intent of this hearing, is to get everybody around the table. Senator Kiffmeyer and then Senator Benson.
The question was asked in regards to the committee. Currently, the Senate file companion to this is in state government. This is where it should be heard by all Senate process. That's where it belongs. A lot of these issues then can be dealt with in state government. I did schedule it for a hearing back a while ago, and it was pulled, not by me, but pulled by the author. And so this should be heard in state government. Madam Chair.
Thank you, Senator Kiffmeyer. Senator Benson.
Thank you, Madam Chair. I have a number of questions, but I'll try to be succinct. Senator Chamberlain, the relationship between the tribes and the tracks. So the tribes get a master's license. Does the track's ability to participate in sports gambling depend on that master license?
Senator Chamberlain, and
Thank you, Madam Chair. Senator Benson. So if I understand correctly, you're asking about the master license in the...
Madam Chair, really,
Senator Benson.
The point of the question is, are the tracks dependent on permission from the tribes in order to operate?
Under this particular language, no. The committee, this language directs two types of licenses in this regard. I mean, there's several types of licenses, but for basically operator license for sports wagering, the two master licenses for operators, which would hold the ultimate responsibility, would be each of the two tribal units, right? And then the commission would also be authorized to issue a license to each of the racetracks. So that's separate. My original proposal in the Senate bill had the master license and then required the tribes to enter into a contract no less favorable with the two tracks. And my original language also had the teams, the 6 professional teams. So in other words, it's a right of first refusal. They may enter into an agreement with the other tribes in their district, but they must reach out to the two tracks and/or at that time the teams and give those tracks the right of first refusal, saying we don't want it, that's fine, or yes, we do want it. Then they have to negotiate terms no less favorable than they did with the other tribes. So my provision, my take was giving the tribes some level of oversight and control. This just takes that middle step away and says 2 to the tribes, and you can give 2 to one each to each of the racetracks.
Senator Benson.
Madam Chair, following up, in our council summary, master sports betting license has an unspecified fee. When do we think that fee will be determined or how it will be calculated?
Senator Chamberlain.
Madam Chair.
And we have a
and-
lot more questions after this, so.
Madam Chair and
I'd
Senator
like to get this
Benson.
done by session.
Yes, that would have to be specified, and I don't necessarily agree with the 20 years. I think that should be a little shorter. I'd have to check to see what our racetracks are under, but I think it should align with our racetracks, and there should be a fee attached to that.
And
Senator
Madam Chair, I will try to be quick. The
No,
other party that is largely impacted by this, the charities, I understand there's a great disparity between the tax rate paid by charitable gaming and the tax rate that would be paid under this provision. And so how do we come to some parity or resolve that issue?
And Senator Benson, I think the answer would be to get everybody around the table. Senator Chamberlain, to get everybody at the table.
Oh, yes. So, Madam Chair and Senator Benson, our intent from beginning too was we understood that charitables would be impacted by this, whether it's state lottery or e-pull tabs and just the regular pull tabs and other charitable operations. We have included them all along the way in the discussions about how we can help them out, keep them all whole, as Senator Rosen alluded to earlier. This particular proposal gives 1/3 to them, and I have admitted earlier that, you know, this isn't a big moneymaker, so a couple of years it gets up to speed. That might be about $3 million, $3 to $6 million. The final part of it is we could do tax reform. So I think, and someone could correct me if I'm wrong, but the current rate, I think, on charitable gaming is 35 or 38%. Maybe Mr. Williams has that number. And what we have here is 10%. So it's well known that the charitable gaming, and this, we try to get this fixed for years as well, over and over and over again, that they pay more in taxes to the state than they do give to their charitable operations, which is really backwards. We've had several proposals over the last 5 or 6 years, and they've all just not been able to get across the line. So we need some parity. It needs to be fixed. The charitable gaming would be happy with tax reform and a reduced rate so they can get more to their operations. I will just say this in the end. We know what they do, right? It's firefighters, it's public safety, it's local schools. There's the largest operator in the state uses that money to support their adult day services. So this is real charity stuff, and they shouldn't be paying more in taxes than they do their charities. So we need to fix it. So I agree.
Thank you. And Madam Chair and
Senator
Senator
Benson.
Chamberlain, as former tax chair, I would concur. There should be parity between these two types of gaming. And I, having not waded into taxes or gambling, think it would make more sense to just adjust their tax rate instead of do this. Well, we'll give them a third, which is looking here about $3 million is a pittance compared to what they pay in taxes. And Madam Chair, and I know we called council up, but I have one last question, then I know we want to
Senator
get.
Benson.
So mental health transfers, and this might be a Mr. Nauman question, so I'm just giving you a heads up. If it comes out of a special revenue fund and it's transferred to the Commissioner of Human Services, does it go in as though it were a grant, and is it then appropriated under the general fund, or is it just given to the commissioner and the commissioner makes that decision? Because, for example, ORAC, we have a council, but there are some grants that are given to the commissioner. Commissioner has discretion. Others, the legislature decides how it's broken up. And I tried to look for the language, but it just talks about a transfer.
Mm-hmm. Thank you, Senator Benson. I think we're going to let Mr. Botter and Mr. Nauman look for that and get an answer back to you.
Thank
Further
you.
questions?
No more questions. Thank you.
Thank you. I think we'll go to Senator Kent since she has not had a question up to this point. Senator Kent.
Thank you, Madam Chair. A quick question for you. Is the plan for this to go onto general orders?
Yes, it is.
Thank you. And so I just wanted to, in light of that, and in light of the fact that this is a busy day and we all have a lot of balls in the air today, and I've been sort of in and out of this hearing, I just wanted to take this moment to just say, if this bill does pass out of this committee, it's clear that it does have a lot of issues and a lot of work does still need to be done. I appreciate, Madam Chair, your comment about getting everybody to the table to really work on this. And so I just wanted to get that on the record. I have a lot of concerns about this bill, but I understand, trying to go through this process to get there. So thank you.
Thank you, Senator Kent. I do appreciate that. Thank you very much. Senator Marty, and then Senator Kiffmeyer.
Thank you, Madam Chair. Our first question I have, are we going to have testimony on this?
Senator Marty, we talked about that yesterday, and I think because of our time frame here, we have to go session in 10 minutes. We have state contracts after that. We are not going to have testimony.
Madam Chair, the reason I ask is because I think we've had very brief discussion. I don't know if it was Senator Champion or Senator Kiffmeyer or somebody about compulsive gambling problems and gambling addiction and impacts on suicide. Because they say, I think the DSM manual for mental health says that I think it was close to half of people who are in gambling addiction treatments have had thoughts of suicide. And like almost 1 in 6 or so have attempted suicide. We haven't had any testimony about any of that. And I guess I think this bill, I was talking with Mr. Bacchus offline about the impacts on what we already call, what I think most of us see as sports betting, pools and so on. And if they're betting more than $1,000 on them, which is not your typical office pool, but a group of friends betting $1,000 on Super Bowl or anything they choose to bet on, it strikes me that that could actually have more severe penalties under this. It's not something I think anybody's hoping to prosecute, but I guess I think that's something that the Judiciary Committee ought to be looking at. And I was a little bit surprised to hear earlier. I assumed that the reason it was here was because this bill had been pulled out of State Government Committee with the jurisdiction. And then Senator Kiffmeyer just said she had offered a hearing on it, and the author pulled the bill. And I have real questions about why 4 days from the end of the session, we're having a bill that's the biggest expansion of gambling. I mean, the mobile gambling, the online gambling is, in my mind, the most addictive, most powerfully damaging one. And we're only affecting those who are, when there's a bookmaker in here involved, not when there's people doing their social bets. So the stuff that people already do is happening, but allowing the bookmakers into the business to do this and all these impacts, and we're not going to have testimony on that. We're not going to have it go through any of the other committees that this ought to go to. I guess I would like us to complete this discussion after session today. I know we only have a few minutes till session, but I'd like us to postpone it till after that. And I guess I wonder what the possibility of that is.
Thank you, Senator Marty. I do believe that the intent is to get this out because we have conference committees. We will have to come back for the employee contracts. Senator Cran, my apologies. You've been diligent. Thank you for sitting here. Senator Marty, I can make a personal guarantee that the Gambling Anonymous or any money for that project or that issue will be vetted through. And Senator Chamberlain has said that. Senator Bingham is nodding her head. I have close ties or experience with this issue with the U.S. Bank Stadium, and we really delved into it, and Mr. Nauman has the statutes up right now, and we definitely need to do something in that arena. That's why I think it's so important to get this going and get the folks around the table and improve this bill to a point where it can take a vote off the floor. But yes, Senator Murray.
But Madam Chair, I guess my concern isn't just giving money to organizations addressing compulsive gambling and mental health challenges, which will get worse. I think we know this is an expansion, but the concern I have is the fact that every Vikings game now, you're going to have ads on the TV screen marketing it to, and they're not aimed at kids under 21 because that's prohibited in the bill, but I don't know how you're going to stop it from getting there. And we cannot, according to the Supreme Court ruling a number of years ago, we can't ban advertising on a lawful product. And so there's going to be, every time somebody turns on Big Ten football, any college or professional sports, there's going to be gambling ads on it. It's going to be pushing kids. It's going to be able to do it. And the thing that the biggest expansion to me is the fact that it's all done electronically. If it's done just where casinos are and so on, I mean, every time we expand gambling, we have a bigger problem with it. I still remember about 20 years ago, young law student, brilliant student, straight A, apparently kind of student, was arrested for armed robbery. And she destroyed her life. And the reason was compulsive gambling addiction. And here we're just kind of saying, well, we don't have time, and don't worry, we'll consider this seriously on the floor. I just think we have 5 committees. Apparently, I was told it was like 5 committees it was supposed to go to. And I thought the reason was that the chair of one committee wasn't giving it a hearing. And now I hear there was a hearing scheduled. The author of the bill pulled it. I think we should wait till next year, Madam Chair.
Senator Kiffmeyer, to that response, please.
Well, it's exactly true, so I don't know what kind of a response you would be looking for me from. I think every single one of these committees, matter of fact, in my time here of being in these chambers, the process, the committee hearings and what they do, and the subject matter expertise that every single committee brings to a bill, there is a reason why we go to those committees. Because they have subject matter expertise to address these things. This isn't just about these stakeholders who all want a piece of this sports gambling. And the biggest stakeholder, the voice of the people of Minnesota, can't be at the testimony table. They're shut out from all this. Where is their voice in this conversation at being able to have their messages that are here, much less the very expansion of gambling, and in this particular way? I'll just read to you. A former U.S. Senator and Hall of Fame basketball player, Bill Bradley, wrote, "Athletes are not roulette chips. Sports gambling treats them as such." Cultural shift of the whole perspective of sports. And when you have state-sponsored sports betting, the character of sports and the youngsters' view of them, the greatest harm is to our youngsters and their perspective of, we talk about character in sports, now it's going to be betting on some of these things. And in Australia and in Britain, they've gone this way. And they've seen the harm and are sounding the alarm and saying, no longer are we focused on the player, teams, and the statistics. Now we're taking a look at the odds, the prices, and the value bets. And it's turned sports into a gambleization of the sports, and the whole outlook is dramatic. And the effect of gambling in the general public, as Senator Chamberlain mentioned, the effect especially inner cities, low income, is particularly bad because they're vulnerable to thinking, maybe I can make it and do this, and they're particularly vulnerable to that. Former federal prosecutor, adjunct professor in a school of law, the 2/3 of Americans who rarely or never engage in this gambling, the change will be negative. Anyone who fairly and comprehensively evaluating the unbiased, independent academic, healthcare, and economic evidence readily finds it weighs in favor of continuing prohibitions on commercial sports gambling. So Britain, Australia, their rise, it wasn't at first, but just 8 years later, tremendous problems. And you can put money into Gambling Anonymous all you want. That will not fix it. And more than anything, for the kids. For us adults, we should sacrifice for the benefit of the kids, not sacrifice the kids for the benefits of the adults. So, Madam Chair, with that, if we're going to take a vote on this, I'll ask for a roll call.
Senator Chamberlain, closing comments, please.
Thank you, Madam Chair. Look, this is Stuff goes on all over the place. I'd say if everybody is so upset about gambling, then what are you to do? Senator Marty, others? You're so upset about gambling. I get it if you got a moral thing with it. If you're so upset, what are you going to do about poll tabs? Did anybody here that was around then, Senator Marty, did you vote for the state lottery? Maybe you didn't. I thought back at the time, state-sponsored was a bad idea, but people voted for it. As I mentioned in my opening comments, I think there's about $10 billion of wagering going on in the state now. So if you don't like gambling, I get it. I get it. But perhaps you ought to do something about what is taking place already. Or maybe think back about if you did vote for the state lottery before my time. But anyway, sports is a big business. Always has been. Always has been. Anybody who thinks that professional athletics and college athletics isn't a big business and hasn't been played that way since its inception, before that, horse racing and everything else is just, I mean, that's just the reality. That's the reality of it. It is. And, I supported the name, likeness, image issue too, because a lot of college athletes were being treated like they weren't being treated properly because they were being used and institutions are making a lot of money off of them. So, and one last comment about the advertising. Look, unless you haven't turned on the TV or your radio or looked on your phone or computer, if you've not done any of that, then I get that you don't think they're advertising already. They are. They are advertising already for all of this stuff. It's already out there. And yes, they can stop advertisement of certain things. Remember cigarettes? That's not out there anymore. Anyway, members, I thank you, Madam Chair, and members for the time. This is a fun activity. It's a smart activity. It will not end the world here. It is something Minnesota should be part of. They continue to go across state lines to do this. So I'm hopeful that you'll vote for this. And the people have supported this measure in great numbers. By large majorities, they support the sports wagering. So thank you, Madam Chair. Thank you, members, for the time and for the discussion.
Thank you, Senator Chamberlain. Clerk will take the roll.
Madam Chair, I have a higher motion.
The chair votes.
Madam Chair, I have a higher motion.
Senator Marty.
Madam Chair, I move that because this bill missed all those other committees, this bill be withdrawn from the Finance Committee and re-referred to the Committee on State Government Operations, which is where it should be. A roll call on that.
Roll call requested, roll call granted.
Chair Rosen.
Chair votes no.
Vice Chair Ingebrigtsen.
No.
Senator Marty.
Aye.
Senator Benson.
No.
Senator Champion.
Aye.
Senator Johnson.
No.
Senator Kent.
No. No.
Senator Kiffmeyer. Senator Lopez Franzen. Yes. Senator Pratt.
No.
There being 4 ayes and 6 noes, the motion does not prevail. Roll call requested, roll call granted on Senator Kiffmeyer's roll call. Chair votes. Oh, excuse me. A roll call requested by Senator Kiffmeyer. I move that Senate File 778 as amended be recommended to pass and placed on general orders. Roll call requested. Ms. Johnson?
Chair Rosen,
Chair votes aye.
Vice Chair Ingebrigtsen,
Aye.
Senator Marty,
No.
Senator Benson,
Aye.
Senator Champion,
No.
Senator Johnson,
Pass.
Senator Kent, Senator Kiffmeyer,
No.
Senator Lopez Franzen, no. Senator Pratt,
Yes.
Senator Johnson,
Yes.
Senator Kent, Senator Kent.
Aye.
There being 5 ayes and 4 noes, the motion prevails. House File 778 as amended is placed on general orders. Thank you, Senator Chamberlain. Members,
Very much, Madam Chair and members.
we are under call, and we will come back at the call of the chair. The Finance Committee is in recess.